Hi, I'm John DiPippa. I am the former dean and the Distinguished Professor of Law and Public Policy at the University of Arkansas, Little Rock William H. Bowen School of Law. I'm here to talk about some issues concerning the recent legislative session. Before I do that, though, remember that I don't speak for the law school. I speak for myself as an individual and as a scholar of constitutional law. So I guess we're ready to go. Well, the answer has to be yes and no. Yes, in one sense they do, because they narrow the focus of House Bill 1228. So for example, in the fixed bills, only the government can be involved. In other words, you can only sue when the government makes you do something. The old bill, 1228, would have allowed private parties to sue one another when one of them was simply following the law. So that's a good deal. But in terms of ultimately fixing the concern that this could be a license to discriminate, it really doesn't answer that question. See, the legislature could have added a provision to the fixed bills that said specifically, this does not allow for discrimination, and then listed the categories. That's exactly what Indiana is proposing to do to fix their bill. Instead, we left it silent. So ultimately, unless something like that's added the next session, this question is going to be up to the courts to decide whether or not this version of Arkansas's Religious Freedom Restoration Act gives people a license to discriminate. Well, the Hobby Lobby decision by the Supreme Court in 2013, for me personally and a lot of other people, was really the game changer in our way of understanding the Religious Freedom Acts. A lot of people like me supported the acts originally because we thought they would be limited to individuals, especially people from powerless or minority religions who were being burdened by, say, the majority law and the perspective that brought to them. So even in the first case that kicked all this stuff off 20 years ago, it was about a guy who participated in a Native American ritual and used a hallucinogen, then lost his job. Well, he tried to get unemployment benefits and was turned down. It seems to me that that's a whole different case than saying to a multi-million-dollar business, you're entitled to pick and choose from the laws that apply to you which ones you're going to follow because you as a business have some religious rights. What Hobby Lobby did was it took what many of us thought was a focus on individual rights and included it to include corporate rights. And there's no logical stopping point. Hobby Lobby is a closely held corporation because it's owned by a limited number of people and it's not traded publicly. But it's a big company. In fact, most people work for closely held corporations. So there's just no stopping point between gradually increasing the rights of corporations in a way that doesn't make any sense. I think only individual human beings can have a conscience, and that's really what religious freedom is supposed to protect, this right of conscience and free thought. Corporations are artificial entities and can't have consciences. Once you start letting corporations take advantage of these religious freedom laws, then you've essentially given them even more power to control life, the marketplace, and everything else. Well, the governor's executive order could only apply to state employees. And so if he issued one, it would say that the state could not discriminate against its employees on the basis of sexual orientation. So it would be limited to state employees. Why that's significant is that in Arkansas, LGBT people have no legal protection whatsoever under any circumstances. So oddly, bakers could refuse to bake cakes for gay weddings, photographers could refuse to take pictures, gay couples could be evicted, you could be sued from your job if you're LGBT. fired from your job. All those things would be perfectly legal as it stands in Arkansas right now. And so if the governor actually did issue that executive order, that's actually a step in the right direction. It doesn't have anything to do with religious freedom, but has a whole lot to do with LGBT rights. Well, that's what's interesting. And that may be the most immediate impact of even the new version of the Religious Freedom Act. Because what it seems to say to that court clerk is you could refuse to issue a marriage license to a gay couple if you had religious objections to it. Now, eventually, maybe you wouldn't win. But what would happen is you'd say no, and then the state employer, whoever that happens to be, would take some action against you, ordering you to do it or firing you from your job. And whenever the state did something to you, you could use this act as a defense. What it does is it shifts the burden of complying with the law from the people who are supposed to provide the service, the government employee, to the people who are supposed to get the service, the gay couple. And I think that's the most likely outcome and the most immediate outcome of any version of the Religious Freedom Restoration Act, when it doesn't include something that says you can't use this to discriminate against people based on their sexual orientation. Hi, Kathy. How you doing? The simple answer is no. Simply calling something historical doesn't make it historical, because you actually have to have history behind it to make it historical. And the reason that this Ten Commandments bill is probably the most unconstitutional bill this legislature has passed this term is that they only look at half of the law concerning Ten Commandments. So the Supreme Court decided 2 Ten Commandment cases on the same day about 10 years ago. In one case, there was a Ten Commandments monument that had been on the grounds of the Texas State Capitol for about 40 years. It was one of 35 monuments, all the rest of which had some connection to Texas history. And the court said, you know, the monument's been there for 40 years. It seems to be part of a secular display about Texas history. And after all, part of Texas history is rooted in some religious practice. So we don't see this as a religious endorsement as much as it is a reference to our history. But then they turned around in a Kentucky case where a Kentucky courthouse installed a Ten Commandments monument. It never had one before, but just put one up. And they turned around in that case and said, there's no history here. You just put it up. And the fact that you just put it up and that people are now complaining about it suggests that it really is an endorsement of religion and not some reference to history. The key here isn't that it refers to some historical notion that the law is based on the Ten Commandments, but the key is whether the historical reference is to something about the religious history of that state. So I don't think you can just call something historical, throw it up on the grounds of the Arkansas State Capitol, and say, there you go, it's all good. That's why I think this is the easiest of all the bills to overturn. Well, here's the problem, and this isn't a new idea. For a long time, the law, and when I say a long time, I mean going back to England, the law has said when you open a business and hold yourself out to the public, you accept the public as your clientele, and you're not allowed to pick and choose who among the public you will serve. That's a long, long-standing tradition. And so I think that's the answer. Once you open yourself up to the public, you give up the rights you might have as an individual to decide who you're going to associate or not. And I think that's the answer, because there has to be a trade-off. You know, if every business owner could say, well, I'm going to choose you, but not you, then we could simply reenact segregation, racial segregation, even though the state didn't force you, you'd have a lot of businesses who would go out and do that. And the market would never really correct that. You know, in a small town, for example, if I'm the only wedding photographer or the only pharmacist, and I refuse to serve certain people based on my religious practices, those folks are out of the market completely, and they'd have to incur extra expense to go somewhere else. So it's not a one-way street. I think once you open yourself up to the public, then the public is entitled to do business with you. Well, you know, this is interesting because we're talking about these Religious Freedom Restoration Acts as though they're striking the balance or returning a balance. I mean, they're talked about restoring religious freedom. Ironically, for most of our history, the Constitution struck a different balance that seems to have worked. And what it said is, people have an absolute right to believe what they want and to speak about their beliefs. I mean, I have an absolute right to believe my faith and to try to convince you to follow my faith. But we drew the line historically at when that belief moved into action. And we said, just because you believe something doesn't give you a free pass from having to follow the laws that everybody else follows. So if a law doesn't target religion, and it's neutral and applicable to everybody, then the law historically said that doesn't violate your religion. What happened with the Religious Freedom Restoration Act, in fact, is that it struck a new balance, which said, even if we're not targeting religion, you can exempt yourself from some laws if they incidentally burden your religion. Even if nobody ever intended it to, if you think it burdens your religion, we're going to give you a free pass out of them. And that, I think, shifted the balance away from the traditional, I think, respect for individual freedom as well as equality toward really sort of a thumb on the scales on the side of the religious believer. I think because well, I'm going to go back and do an academic answer. I mean, James Madison is considered the founder of the Constitution. And one of the things Madison feared the most was majorities. He feared that in a pure democracy, the majority always won. And the reason it always won is simply not because they had the best argument or they were the most principled, but because they had the most power. And so he was always concerned that that wouldn't be an effective way to govern, that the rights of the minority ought to always be considered and understood and respected. And so in order to do that in a system that has both democratic procedures and constitutional rights, we have to make sure that the majority doesn't purposefully or accidentally run over the minority. Because, again, if you have all the power, you may not even understand what the interests of the minority are. So we need to protect minority rights so that when we try to make decisions in the political process, their interests are heard and respected. Everybody wants to believe that what they're doing is correct, and everybody is blind in many ways to the perspective of other people. If you get a bunch of people together who all think alike and act alike, they may never understand that what they're doing is really burdening a lot of other people and may see those other people, in essence, as whining and not deserving of respect. So I think James Madison would say, we need to make sure everybody's heard, and the only way to do that is to vigorously protect minority rights.